When does intimidation become a felony? Intimidation is when you communicate a threat to a person with the intent to place them in fear of that threat, and that threat would be carried out. Usually, that alone is a misdemeanor. So if I tell someone I'm going to punch them in the face, I'm communicating a threat to them. Now, it doesn't matter if they believe that I'll punch them or not. All that matters is that I intended to put that fear of that threat into their mind like I was going to carry it out. Intimidation can become a felony, though, in a number of ways. If you threaten to actually commit a felony to that person, so if you say, I'm going to shoot you, well, shooting someone can be a felony. So that could lead to intimidation as a level 6 felony. If you threaten someone who is a witness in a criminal case saying, don't testify in court or I'm going to beat you up, that can be considered a level 6 felony. And if you have a deadly weapon on you when you do that, intimidation can be charged as a level 5 felony. So there are some examples of a deadly weapon, a gun, a bat, a knife. Those could be considered deadly weapons, but sometimes there are other things that could be considered deadly weapons, like a cane. So if you hit somebody really hard with a cane, that could be considered a deadly weapon in certain examples. Another thing that often charged as a deadly weapon is a vehicle. If you're threatening to drive somebody over in a vehicle or you're communicating a threat saying, I'm going to run you over, now we're talking about intimidation that could be charged as a level 5 felony based on the vehicle being a deadly weapon, even though a vehicle generally isn't considered a deadly weapon. So if I had a pocket knife on me and I was concealing that pocket knife and I made that same threat to somebody, well, it might not be considered intimidation as a level 5 felony because they didn't see the pocket knife. If they take the pocket knife out, and I threaten them, then we might be talking about a level 5 felony. This can get really complicated if you have a firearm. Say if I have a firearm tucked underneath my hip and I'm not brandishing it, I'm not showing it to somebody, and the other person doesn't even know that it's there, but I did have a firearm, that might not be intimidation as a level 5 felony, even though I had a firearm on me. Let's say I pull up my shirt when I'm making the threat to somebody and they can see that there's a firearm on my hip. At that point, that could be considered like I'm drawing the weapon, even though I don't pull it out. So it can get a little complicated there. Now, obviously, if I take the gun out and I point it at somebody and I communicate a threat to that person, we're definitely talking intimidation as a level 5 felony at that point. But we'd also be talking about pointing a firearm as a level 6 felony. So if you or someone you know has been charged with intimidation, call us at the Marc Lopez Law Firm at 317-632-3642. And remember, always plead the fifth.